Seek your lordship's indulgence in making a mention with regards to part 2, item number 4. My lord, if this matter can be taken up after 3 weeks, this matter is handled by Miss H. Swami.
Yes. Counsel for the petitioner.
We have no objection, my lord.
Okay. Mention is made by Ms. Caroline Kielalong Oipui, learned counsel, learned government advocate for the state respondents for adjournment of the matter. Since this matter has been taken up by Mrs. Malswamy, learned government advocate, who is on leave, who has taken leave of absence. Why? Why has she taken leave?
Maternity leave.
Maternity leave, my lord.
Okay. Since she has taken maternity leave. Miss
Ropare.
Lord Ropari, learned counsel for the petitioner, has not raised any objection. In view of the above, list after 3 weeks.
May I seek your lordship indulgence in making a mention of part 2, item number 10.
Yes.
If the matter can be taken after 1 week.
Miss Ropari, learned counsel for the petitioner, has prayed for adjournment of the matter. In view of the above, list after 1 week.
Obliged.
Promotion, item 1.
Okay, instead of in view of the above, accordingly. Okay, list after 1 week. That last order. Yes.
Yes, Lordship, this instant petition is regarding the acquisitions of the petitioner land by the respondent sometimes in the year 2021.
Yes. What is it about?
Lordship, in this writ petition, the petitioner was not given a compensation from his land, even after giving several representations. If I may
Several?
take representation.
Okay.
If I may take my Lordship, at page number 96 and excerpt 22. And the translated copy is at page 96A. And Lordship, this is the representation reminder of the previous representation dated 14/11/2022. If I may read it, Lordship. I have resubmit and request you to take necessary action of my representation dated 14/11/2022 regarding my agricultural land, periodic pata allotment number 3091/12/1991 of 2004, since now it is paid. The sustenance of my family depends on this agricultural land. We are deeply elated that National Highway 6 will be going through our land. However, our neighboring lands and all those affected by this development of National Highway 6 have already received the actual value of their land. However, we do not receive any compensation. I kindly request you to please take necessary steps so that we could be receiving the actual damage value from our land. And Lordship, after this representation, the respondent
What
number,
is this? I have enclosed my.
I have enclosed my representation dated 14/11/2022,
Along with?
along with senior civil judge order in declaratory suit.
So what does that mean? Senior
This
civil
declaratory
judge?
suit is regarding the declaration that the periodic pata number 3091/12/1991 of 2014 is indeed the lands of the petitioner. This is
Okay,
because
you had some dispute before this, is it?
no dispute, Lordship. The thing is that I have purchased this periodic pata from the previous owner, and after that I did not mutate the said periodic pata in my name. So after the respondents issued the notification, I was intimated by the
Okay.
respondent number.
Yes.
Respondent number 6, that is Kala, that I need to acquire declaratory sheet declaring that I have ownership over
Okay,
the
so
said
now you
property.
have that.
Yes,
Okay,
Lordship.
fine.
And after the representation reminder, Lordship, the respondent number 6 issued a meeting notice on 5th January 2024 regarding the representation reminder received from the petitioner, which is at Annexure 97, Lordship. Page number
Annexure
97,
24,
Annexure
yes.
24.
Yes, then?
And after this, Lordship, the respondent number 5 again issued a order that is on page 98 and exit 25. That order is regarding the meeting which was held on 9/1/2024. And in that meeting, Lordship, the respondent number 1 issued an order for re-verification of the petitioner's land. The name of the petitioner is at serial number 1 of the order, and excerpt 25, page number 98. And after this, Lordship, on on 15/1/2021, the respondent number 5, along with the surveyor, which is the respondent number 8 hearing, had a joint verification of the petitioner's land, which is at Annexure 99, Annexure 26, page number 99. That is the joint verification report.
9th January.
Yes, translated
Okay,
copy is at
yes.
99.
Yes,
If I may
yes.
go to it, Lordship.
Yes.
I submit the report of the joint verification regarding the complaints in the development of National Highway 6 in pursuant to above order. We have verified the complaint by Sri David Lalam Sanga. A crop compensation was received by Sri Kaikomanga and Sri Thangkandimi by using VC pass from the said lands. Since it was within Sri Sang Biakvela periodic pata number 19 of 2004, a complaint was made claiming land value. Since the pass belonged to Sri Sang Biakvela, it is proceeded that the file shall be made in Sang Biakvela name. As per the initial road design map, the land was only 100 meter. Due to the excavation mistake, the land becomes 170 meters. Though a compensation was already claimed using VC pass, since it is well within a land given by government, it is concluded that a new claim shall be made and prepared with respect to the owner of the name. Respect to the owner name Sri Sang Biakvela, I have submitted this report for necessary action. And what happened, Lordship, after this verification report, the respondent number 8, that is the surveyor, submit his joint verification report, which is in English, and that is at Annexure 100. The verification report which the respondent number 8 submitted in Mizo version and English version are completely different. And Lordship, if I may go to the joint verification report submitted by the respondent number 8, which is in English. I have annexed Annexure
Page?
number 7, 100, page number 100.
100.
Yes. If I may go to Lordship.
Yes.
With reference to your order number and dated cited above, I have the honor to submit here with joint verification report for favor of your kind information and necessary action. Joint
So you're
verification.
saying that page 99A and page 100 are different?
Yes,
Is it?
both are the joint verification report submitted by the respondent number 8, that is the surveyor. However, these both joint verification reports are completely different and their contents are completely different.
Okay.
If I may go to the
Yes, yes.
With reference to your order number and dated cited above, I have the honor to submit here with joint verification report for favor of your kind information and necessary action. Joint verification team comprising of Kala, National Highway 6, surveyor from Land Revenue Department, representative from NHIDCL, SBCC, VC Chungte and landowners conducted joint verification on 15/1/2024. Following a discussion held to this effect on 9/1/2024, who David Lalam Sang has submitted complaint with respect to denial of compensation in respect of periodic pata number 191 of 2004, registered in the name of Sang Biakvela located, Chainage left hand side 106, 150 to 106, 200 and right hand side 106, 200 to 106, 250 under Chungte Village Council. VC
See,
Chungte-
1 minute before
Yes,
you go ahead. if you look at page 99,
Yes, Lordship.
okay, when you look at page 99, now the date which you just read out at page 100,
Yes, Lordship.
it says that joint verification report was conducted on 15th, 1,
Yes.
so and so. But if you come to page 99 and you look at the date,
Yes,
the date signed by Mr. H. Lalrinzwala,
yes.
the
It
date
says
here
10
is
1.
10/1/2024.
Yes, Lordship, I'll come to that. I think this might be a mistake or an error committed by the respondent number, right? I think so.
Mistake, or maybe there were different verifications done. This is one and this is the second. Anyways,
Yes,
just
Lordship.
read.
Okay.
The dates are different. This is 10/1, while here it mentions 15/1,
And Lordship,
and this is 31
Yes.
when this letter was made. Anyways, please read.
okay. VC Chute has earlier issued VC passes to Kai Komanga pass number 30 of 2016. Of Chungte and Pitang Kandimi pass number 4 of 2015 of Chungte over an area contested and claimed by Pusang Biak Vela in 2016. And both have received compensation from the above, have received crop compensation from the above areas in 2001. However, from the light of complaint received from Pu, David Dalramsang and subsequent joint verification conducted, it appears that the area in question covered under periodic pata number 191 of 2004 is overlapped with two VC passes issued to Pu Khai Komang and Pitang Kandimi, for which both have already received crop compensation as well. Whereas plot of land cover under periodic pata number 191 of 2004 belonging to Pusang Biak Vela has not yet received any compensation from the same area already acquired by NHIDCL for the project widening of two land paved shoulder Dulte to Champai. It may be reiterated that periodic pata number 191 of 2004 issued by government in 2004 is more senior to VC passes issued by Chungte Village Council in 2015 and 2016 respectively. And also the former prevailed over the latter in terms of legitimacy and seniority. Whenever any dispute is arisen between them, as per the Mizoram Revenue Act Rules 2013, during the course of discussion held and spot verification conducted, both VC passes and periodic pata holder have unanimously resolved that land value and other benefits due for this particular area be assessed in respect of the owner, in respect of the landowner of periodic pata 191 of 2004. As VC pass owner have already received crop compensation. As such, being the case, the complaint received necessitated joint verification, and the same was conducted on 15 January 2024. Lordship, here, the respondent number 5 has clearly stated that the joint verification was conducted on 15 January 2024. That is what I have.
So that joint
That is-
verification report is
Yes.
required,
Yes.
because this is 10/1.
Yes, that is why I think this might be a mistake committed by the
I
respondent.
don't know, you think, but we don't know.
As such, 2004 with the recommendation that land value due for the area covered under periodic pata number 191 of 2004 in the name of Sangbiak Vela be asserted and disbursed the same to the landowner. As per the initial roadmap designs, the probable acquired stretch of the land was 100 meters only. However, during actual excavation, a little area over the initial armac area was taken, leading to the extent of the area becoming a little wider, that is 170 meters.
Anyway, we'll issue notice. Let's see what is going on, what they have to say concerning this. Now, what is this reply to RTI application?
Yes, Lordship, that is, since there are lots of inconsistencies in the joint verification submitted by the respondent number 8, that is the verification report submitted by the respondent number 8 in Mizo and English. I have taken steps by applying
Okay, now, your main prayer is for payment of compensation
Yes, for
with respect to periodic pata 191 of 24.
yes, Lordship, spot verification.
Okay, now what about the VC parcels? That is covered by a different plot of land.
Yes,
is it?
Lordship.
Not within the same land.
it is within the safe lane, but Lordship, VC pass number 13 and VC pass number,
If compensation has been given for that plot of land,
yes,
then how can the respondents give double compensation?
no, it's not double Lordship. As per the initial chainage, the land of the petitioner was affected. Only 100 meters was affected.
Okay.
But
So you're saying that the
Yes.
VC pass
yes,
for which compensation has been paid
yes,
is not covered by the periodic Pata 191 of 24.
it is covered by,
Some portion,
yes, some portion
not
was
the whole
covered.
portion.
Yes.
Okay.
70 meters of the petitioner's land was, is remaining.
Okay. So you're praying for the remaining portion
Yes. As well as a spot, as well as another spot
as
verification.
per the spot verification that is made. So now a decision was already taken. This was taken on 31/20/24.
24,
Then
yes.
what happened after that?
After this, the petitioner opposed the respondents again. However, the respondents informed the petitioner to approach executive director NHIDCL. Since the petitioner doesn't have any problems with the executive director NHIDCL, it is only, our problem is mainly with the respondent number 5, that is Kala. Kala did not take any further step regarding the petitioner's land. At some point of time, the petitioner opposed the respondent number 5, that is Kala. At some point, the respondent number 5 threatened to get him arrested, Lordship. This being the very reason he stopped approaching him.
Anyway, we'll show notice. Let's see what's going on. Heard, mister?
This is Otan Sama.
This is Sanga, Learned Counsel for the petitioner. Full stop. The next para. This is, no, the instant writ petition filed under Article 226 of the Constitution of India is for the issuance of the appropriate writ or order to the respondents on the ground that the respondents had acquired the landed area belonging to the petitioner covered by periodic Pata number 191 of 2004. In the year 2021-2022, comma, with regards to KM 1302, KM 147, okay, stop, 25, within Champai district for the development of National Highway number 6 under National Highways Act, 1956, within brackets 48 of 1956, close bracket, full stop. The Learned Counsel submits that even though the joint verification report conducted on 15 January 2024 by the respondents clearly shows that the land covered under periodic Pata number 191 of 2004, which is in the name of Sangbiak Vela, has been encroached upon and acquired for the construction of the development of National Highway number 6. However, no compensation has been paid to the petitioner who had purchased the land from the said Sangbiak Vela, and the district court and the senior civil judge in a declaratory suit. What is the declaratory suit number? It's not mentioned here.
Declaratory suit number 19 of 2022.
19 of 2022
22.
had declared him the owner of the said periodic pata. Full stop. New para. Issue notice of motion to the to the respondents. Miss Caroline K. Lalung Oipui, learned government advocate, accepts notice on behalf of respondents number
7 and 8, my lord.
7 and 8, comma, Mrs. Zairem Sangpui, learned CGC, accepts notice on behalf of respondents number 1, while Mr. Samuel L. Sangte, learned standing counsel for NHID L, accepts notice on behalf of respondents number 2 to 4. No need to issue any formal notice. Full stop. Then new para, requisite extra copies.
My lord,
Notice
if I
notice
may,
may be issued to the respondent number 5.
Okay. After that, notice be issued to respondent number 5 and 6 through registered post with AD within 3 days, returnable by 3 weeks. Full stop.
my lord,
List after 3 weeks.
as
Yes.
per the last court's order, the petitioners were directed to submit the translated version of Annexure 7.
Have you?
And yes,
Yes, Lordship, I have already.
It's there. I think
submitted.
it's there.
I have not received, my lord.
Okay, give a copy. Okay. Within 3 weeks. Okay, list after 3 weeks. Meanwhile, requisite extra copies of the writ petition to be duly furnished to the learned counsels for the respondents. Yes.
Obliged, Lordship.
Item 2.
May it please your lordship?
Yes.
I am the owner of a landed property covered under LSC number 3 of 1987, located at Luang Mall, Aizawl. While I was having undisturbed possession of the land, the respondent number 5 had constructed a geotechnical laboratory within my land, my lord. In the meantime, land lease certificate number 176 of 2008 was also issued to the respondent number 5.
Within your land? No.
No, my lord.
Okay.
So the respondent number 5 requested for verification of the land, and the spot verification was conducted on 24/10/2017. That is the first spot verification. The first survey report was submitted on 25/10/2017, which is at annexion number 5. It was stated that the
Let's come to annexation number 5.
yes, page number 41 is the true English translation, my lord. If I may read from paragraph number 3. Mr. David Mington Moyo, LSC number 3 of 1987, and Mr. John L. Nexiama, LSC number 1 of 1987, landed properties are situated within Luang Mall G&M house site plan. Phase 1 area, and there has not been any evidence of them giving away any portion of their land to anybody. However, on the upper part of their LSC, a motor road was constructed traversing through the house site land, and just above the said motor road, a small portion of land was left. And in the year 2008, the GNM department had constructed a geotech site RCC building measuring 12.40 meter by 8.00 meter in area on that small portion of land. In addition, a temporary building with a clay floor and a corrugated iron roof was constructed by Mr. Ming Dailova of Luangwal High School, Veng, and he continued to live in the said house as well. All the aforementioned constructions are within the LSC of Mr. David Ming Moya, which is the petitioner, and Mr. John Lel Neisiama. That I would like to bring to your lordship's notice that it had, on the first survey, it was verified that the geotech building was situated within my land. Thereafter, the respondent number 7 conducted a meeting wherein all the parties were called to his office. On 18/12/2017. Therein, we went to the office of the respondent number 7. The respondent number 5 was also present, and therein it was discussed that the geotech building was within my land.
Where's that?
It is at page number 40. 46 is the English translation. Paragraph number 3. At the same time, the Geology and Mining Department had constructed a geotechnical building, concrete building within the LSC number 3 of 1987, owned by David Ming Moya, and several machines worth lakhs have been placed inside the building. Their matter was also discussed and were directed to deal between themselves, and if any complications or problems arise, report shall be submitted to us.
This is the English translation.
Yes.
Where's the
The original is page
original?
45, my lord. Annexion number 7.
So this 45, it's written in handwriting.
Yes,
It is not signed.
this is the note sheet, my lord.
Note sheet from an office file, is it?
Yes, my lord.
Even then, even if it's a note sheet, someone should sign on the note sheet.
So, my lord, if I
Who had
may,
made these notes? It will be signed and forwarded to someone else. Isn't
We-
it?
yes,
So
my
this cannot be the minutes of the meeting also. What is this?
we have obtained this note sheet through RTI, and if I may have your lordship's attention to the last line, the page is even incomplete and cannot be read out what it has been said therein. But since I assumed that
This is which department? This is very vague. Anyways, just continue. Let's hear you. Huh.
yes, the respondents number 5 were informed that their building has been constructed within my building in that meeting. Thereafter, another spot verification was conducted on 25/9/2018. Prior to that, I had submitted my representation to the Honorable Minister, praying to relocate the building somewhere else and to remove them from my land. In response to that, the respondent number 5 also submitted a letter, my lord, which is at page number 53, annexion number 10. The portion I would like to have your lordship's attention to is at page number 54, paragraph number 7, subparagraph 2. In this case, it may be clarified that at the time, that is 24 October 2017, spot verification was taken. There was no physical measurement of the LSC of Pu David Ming Moy, rather only scale measurement of the map was done by the representative of DLR and S. Therefore, no concrete decision can be made at this length. Hence, without physical measurement of the area, this scale measurement on the map could not be taken as concluding factor that there was encroachment within the land. Physical measurement of the said LSC was done by our directorate on 4/5/2018 and found certain differences resulting in the reliability of the scale measurement of the map questionable. Thereafter, my lord, in pursuance to that, another survey was conducted on 25/9/2018.
Where's that?
Order was given to all the parties through order dated 19 September 2018, page 55, annexure 11. The true English translation is at page 56, my lord. So after the verification was conducted, the respondent number 5, the Director of Geology and Mineral Resources, was issued a letter dated 6/12/2018, which is at page 57, annexure number 12, and was informed that the building they had constructed, it was within my land,
Where's that?
at page number 57, my lord.
No, here it says that we hereby inform you that your building constructed. That means the building of the director
Yes, my lord.
falls within the LSC of someone else.
Yes, that
Now
would be
here,
me.
this, if you look at 58, that means the director and Mr. Ming Dailova.
Yes, there is one individual person who was also encroaching upon our lands, my lord.
Falls within the LSC of someone else. Who is this someone else?
Someone else would be, that would relate to me and my brother, my lord, as has been called upon by the verification order at page number 55. The true English translation is at page number 56. If I may read. Order dated September 19, 2018, number so and so, as requested by the Director, Geology and Mineral Resources to conduct spot verification on the department's landed property DLL 176 excuse me, of 2008 and Shri David Ming Thanmoya's landed property LSC number 3 of 1987, Shri H. Vanethang, a surveyor 1, and Shri Sila Rinsang, a revenue field worker, were instructed to do the same on dated 25/9/2018. In addition, Shri John Lilne Siama had also requested to perform spot verification of his own landed property under LSC 1 of 1987, at the same time as his brother's landed property would be the site of spot verification. Shri H. Vanethang, a surveyor 1, and Shri Sila Rinsang, a revenue field worker, were detailed on this day to conduct the same. So in pursuance to the order, survey verification was conducted on that date, 25.
So you are John Lalne Isiama, is it?
I am
This is
David
concerning
Ming
the land
Thanmoya.
of John Lalne Isiama.
No,
Your name is not mentioned here.
I am David Ming Thanmoya, ma'am.
This is to see whether
It is at
if
line,
there's encroachment over the land of John Lalne Isiama, isn't it? This
no,
annexure.
no, my lord.
How can
If I may have your lordship attention at line number 3,
3, 1, 2, 3, yes.
yes. Request spot verification on bonds
Okay,
and
yes,
Shri
yes,
David Ming
yes.
Thanmoya, yes.
David Mingthan Moya. Okay. Yes, then
So after the verification was made, it has been reflected in the letter dated 6 December 2018, based on the land verification conducted on 25/9/2018.
yes, then what happened?
It was intimated to the respondent number 5 that their construction has fallen within my land, my lord. Thereafter, I executed the power of attorney in favor of Srimati Julila Ramsiami to appear on my behalf. And on my behalf, legal notice was sent to the respondent number 5 through the council, my lord, which is at page 61, annexion number 14. So after the notice under section 80 of CPC was issued,
You approached the civil court, is it?
not yet, my lord. Another spot verification was again
Okay.
conducted. So which was conducted on 21/8/2019. it was also verified that the construction of the respondents number 5 building was within my land, my lord. The duty report is at page number 69, English translation, annexion number 16A, paragraph number 2. Accordingly, the surface distance of Srimati Julila Ramsyami, who is my power attorney holder, LSC number 3, ISZL 3 of 1987, and the boundary pillars BP therein, BP number 1 to 2, 2 to 3, 3 to 4 were also verified. It was observed that Geology and Mining Resources Laboratory Building and Hing Dialovas Building was confirmed to be within the area of Srimati Julila Ramsyami's LSC. Boundary pillar was instantly fixed. Thereafter, I approached the civil court, my lord. However, since the fact has already been ascertained that the respondents number 5 constructions of building has fallen within my land by various spot.
Now, who's this Julila Ramsyami?
She is, I executed a power of attorney, my lord, in her favor at page number 59, annexion number 30.
So power of attorney, but the LSC is in whose name?
In my name, my lord. So she appeared on the day of the verification on my behalf.
Anyways, this is wrong. Then her name shouldn't be there. Your name should be there. Whoever appears, appearing on behalf of so and so, isn't it?
Yes, ma'am.
Yes. Anyway, that's 69. Then you approach a civil court.
Yes, my lord. However, since the fact of that the respondents number 5 construction was clearly within my land, which has been verified on multiple times, I withdrew the civil suit on 8/3/2024, my lord.
With the liberty to fly
Yes,
afresh. Then what happened?
So after that, my brother submitted a representation. No results. After that, I again submitted a representation on 24 July 2024, my lord. Still then no results has been
No response.
yes, no response or results has been seen from the respondents number 5. So we have no other alternative but to approach this honorable court for relief, my lord. We pray that the respondents may be directed to acquire my land or the small portion of my land wherein they have constructed the building, and to pay the compensation as per the right to fair compensation.
So I think we can dispose of this writ petition at the motion stage itself by telling the state respondents to respond to your representation. They have to do something, isn't it? Yes. Government advocate, what do you say? She submits that she has made representations to the state respondents. Representations dated 16th April, made by her brother. Is this your brother, John?
Yes, my lord.
Isyama? And then on 24th July 2024, he had also made a representation. But no response till date. Now here, there's only one petition, David
Yes, my lord.
Mingthan Moya. What about this other person, John?
My brother, my lord, I would like to state that within his land, a private individual was constructing a building, so we will be taking up that matter in the district court, my lord.
Okay, so yes, so we'll dispose of the writ petition at the motion stage itself, informing the state respondents to respond and consider the representation dated 24th July 2024, isn't it? Thereafter, depending on the response, you can always approach the appropriate forum again. Yes, I'll pass the order later. Accordingly, writ petition will be disposed of.
Much obliged.
For admission, item 3.
Yes,
Lordship, this is a review petition, Your Lordship. Lordship, the review petitioner was the defendant number 7 in the civil suit number 52 of 2011. And the respondent number 1 herein was the plaintiff in the said civil suit. And the respondent number 1, who was the plaintiff, filed a suit for declaring or cancelling the letter issued by the state respondents, Your Lordship, wherein the state respondent had issued a letter directing the respondent number 1 to demolish the steps constructed by him, Lordship, and also directing the respondent number 1 to demolish the steps within 20 days of the issuance of the said order, Lordship. And thereafter, the learned trial court had passed an impugned judgment and order dated 13/12/2017 in favor of the respondent number 1 without exhaustively examining the several spot verification reports done by the state respondents, Lordship, and failing to take into consideration their findings and concluding that there was no vacant land between the two land passes. One is the pass belonging to the respondent number 1, and the other is the review petitioners, Lordship. And as per the spot verification, the state respondents stated that there was a vacant land between the two passes, which is 0.40 meters, Lordship, and that was not considered. And being aggrieved by this order, judgment and order, and the petitioner came before this honorable court by filing an appeal, Lordship, which was registered as RFA number 20 of 2018. And however, the appeal was dismissed by this honorable court on the ground that the spot verification was done on the suggestion and in the presence of the counsels of both the parties, and the findings and observations that were made there were in the interest of the case and to secure the ends of justice, and hence should not be questioned at a belated stage, Lordship. And again, being aggrieved, Your Lordship, the review petitioner has come before Your Lordship.
Well, let's see the operative part of the judgment for which you have come for review.
Lordship,
Read
yes.
that para.
Yes, Lordship, which is at Roman number 11, Roman number 11, Your Lordship, paragraph number 19.
19.
19.
Read it.
This court finds that since the spot verification was done on the suggestion and in the presence of the counsels for both the parties, the findings and observations made therein, which is in the interest of the case to secure the ends of justice, should not be questioned at a belated stage. This court is also of the considered view that the issues framed by the learned trial court has been aptly dealt with in the view of the observations made by the learned trial court, wherein whether there is a vacant government land measuring 0.40 meter between the LSC numbers such and such is no longer of significance, especially so when the state respondents have failed to appear before the learned trial court and have not pressed the matter in appeal.
Okay. So your case was that this vacant land,
Yes, Your Lordship.
0.40 meters,
Yes.
belongs to the government, does not belong to neither of the parties.
Yeah, Lordship, they are the parties before the learned trial court, but they have not adduced evidence. So the learned trial court says that in spite of giving a sufficient chance, since they have not come
Okay.
before the
The government,
yes, the government. They are,
because they are not interested. Okay.
yeah, they are not interested.
Yes.
But they have
So we
issued
cannot consider that, huh?
yes, but they have issued the notification saying that the respondent number 1 should demolish the steps which is constructed in the vacant land, Your Lordship. That was in their
So you are the respondent, you are the appellant / respondent, is it?
yes, Your Lordship.
So you are supposed to now demolish the steps.
No, Your Lordship, they are the respondents, plaintiff before the trial court, and I was the defendant.
Okay,
before
so who is supposed to demolish the steps?
I think she is the one.
She's the one to demolish the
Yes,
steps.
yes, the ones.
And she's not aggrieved by the order?
The
Why have you
order
come
was in
before
her
this-
favor, Your Lordship.
Who constructed the steps?
She had constructed the steps.
She constructed the
Yes,
steps,
Your Lordship.
and she was asked to demolish the steps.
Actually, Your Lordship, she had
So what's
constructed.
their grievance?
Yes, she had constructed the steps in the vacant land. Then the government says that, no, 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 this is the vacant land. It's not within your LSC. You have to demolish.
Oh, so
Then-
she has done that.
Yes, then they have challenged that order before the this trial court, Your Lordship. And I was a party in that.
No, what I'm trying to understand
Lordship.
is now she has constructed some steps within a supposedly vacant land.
Yes, Your Lordship.
Okay. Now, the government says that you have to demolish the steps.
Yes, Your
And that order was upheld
Mm.
by the court
Yes, Your Lordship.
and also upheld by this court to demolish the steps?
No, no, Your Lordship. Because of the fact that they have not adduced evidence before the trial court by the state defendants.
But
And it
they're
was-
they're not unhappy with that. They have not come on appeal, nothing, isn't it?
Yes, Your Lordship.
So
But
now-
because of that reason, Your Lordship, this my
You
land
cannot
was
you cannot insist that they adduce evidence when they don't want to adduce any
yes, Your
evidence,
Lordship.
isn't
But
it?
because of that, I was suffering, Your Lordship.
How are you suffering? Steps are constructed and she's asked to demolish the steps. Steps are demolished. Now what's your problem?
My problem is, Lordship, because of that steps, I'm not able to enter in my lower part of the land, Lordship.
But who constructed the steps?
She had constructed the steps.
Then why should you use a step constructed by someone else?
If that is a vacant land, then we can use, me and her, we can use together, Lordship. And that's why I have made a complaint to the revenue authority, saying that because of this construction of the steps, and I am not able to enter into the lower part of my land.
So because of the construction of the
Yes,
steps, you
Lordship.
cannot enter into the lower part of your land.
Lordship,
Okay?
yes.
So now the order of the trial court was that you demolish the steps, demolished. Now what's your problem?
No, the lower court says that, may take Lordship to lower court order, Lordship, which is at page 22. Page 22. Page 23, Lordship, para 19. Para 19.
Yes.
As stated earlier, the defendants number 1 to 6, their had failed to prove the existence of vacant land between the two parties as desired by the court, and within the stipulated time before this court, the plaintiff also submitted that even if the step constructed by the plaintiff falls within the vacant land lying between LSC such and such belonging to the defendant number 7, but as per office memorandum such and such, the defendants number 1 to 6 are bound to include it within the LSC number such and such belonging to the plaintiff because he has developed it and he deserves the suit land. Exhibit P31 is the office memorandum dated such and such. In this regard, since the state defendants did not contest the case, there appears to be no denial of the above cited office memorandum such and such. Hence, in respect of the office memorandum such and such, the state defendants are at liberty to consider to include it in the plaintiff's land as the steps are an integral and necessary part of the plaintiff's building and does not construct the defendant's number 7 building. So that is the findings of the Learned Trial Court, Lordship,
Which was upheld.
which was, yes, Your Lordship, which was upheld by this honorable court in the
So,
RFA.
so what's wrong? Why have you come for review?
Lordship, because that the Learned Trial Court had concluded based on the spot verification done by herself, Lordship. And that spot verification was done as per Order 18, Rule 18 of the CPC, Lordship. And there is a clear violation of Order 18 of the Order 18, Rule 18 of the CPC, Lordship.
Even if the report is made, what difference would it make to the state? Order?
Order 18, Rule 18, Your Lordship. Power of court to inspect. May I read, Lordship?
Yes, go ahead.
The court may at any stage of the suit inspect any property or thing concerned which any question may arise.
Wait, let me come to the page. Order 18.
Order 18, Rule 18, Lordship.
Rule?
Rule 18, 1-8. power of court to
Yes.
inspect.
Go ahead.
The court may at any stage of a suit inspect any property or thing concerning which any question may arise, and where the court inspects any property or thing, it shall, as soon as may be practical, make a memorandum of any relevant factors observed at such inspection, and such memorandum shall form a part of the record of the suit. Your Lordship, this is what the Order 18, Rule 18 talks about, Your Lordship. However, the learned trial court had failed to make a memorandum of relevant facts. Lordship, that is mandatory. So when it conducts a spot verification, it has to make the memorandum of relevant facts. And there has no record to indicate that whether any memorandum of inspection was prepared by the learned trial court. So, and the learned trial court was solely based upon the impression formed by the spot verification report done by herself, Your Lordship.
Now,
Lordship,
when
yes.
in the RFA,
Yes, Your Lordship.
we listen to the, we'll hear the other party, but
And Your Lordship, besides that,
yes, go ahead.
besides that, Your Lordship, may take Your Lordship to page 22 of the review petition, Your Lordship, page 22. Page 22.
I'm looking at your submissions made
Yes, Lordship.
at the time of the appeal. Whether you had come with this point when the RFA was being heard. Anyways, go ahead. And then?
Lordship, and then my second point is regarding the new issues framed by the learned trial court while conducting the spot verification, Your Lordship. That was at page 22, Your Lordship. An opportunity was not given to the this review petitioner, Your Lordship, which is at page 22.
See, now those points which you have raised now, were they raised at the time when the RFA was heard?
Lordship, yes, it was raised.
Then if this court had decided on those matters, why have you come again?
Uh,
If it was raised then, and the court had already discussed and heard those points, why are you coming again?
Lordship, that the second point
Because
was
some new fact, something that was missed by the court when the RFA was heard, then you come for a review petition.
Lordship.
Some points that were not raised,
I understand.
some new
Lordship.
facts that had developed,
Yes, yes.
and because of that, you file a review petition, isn't it?
Yes, Lordship.
Now,
yes.
if all those issues were discussed when the RFA was disposed of, why have you come again? That's what
Lordship,
I'm trying
yes,
to find out.
some of the issues are not raised before this honorable court at the time of the
Why
filing the
didn't you
offer.
raise those issues?
Lordship,
It would be something that was not within your knowledge at the time when the RFA was being discussed.
Lordship, yes. That,
So
which
what?
is at page 22, Your Lordship. May I
Page
take, Your Lordship,
22.
Page 22.
Just a sec.
Lordship, which is in the middle portion. There are two important issues that arises for consideration. If Your Lordship got it, there are two issues. Lordship, these are the issues framed by the learned trial court while conducting the spot verification, which is beyond the issues framed in an open court. There are three issues before, Your Lordship. That was, evidence was adduced based on the issues framed in an open court, Your Lordship, which is at page 16 of this judgment, Your Lordship. I take Your Lordship to page 16, para 9. There are three issues, Your Lordship. And these issues framed by the court in an open court, based on these issues, evidence was adduced, Your Lordship. But at the time of spot verification, these issues has came up, and opportunity was not given to the
So all
petitioner,
this
Your
you knew when you filed your RFA?
Lordship.
This is not something new, some new facts that were discovered for review. Anyways, go
Yes,
ahead.
yes, yes.
Please discuss.
Lordship, yes, I understand that review
Yes,
petition
yes,
is
yes.
very narrow, I understand.
Uh-huh.
In this regard, may I take Lordship to the citation?
Yes.
Yeah, the operative is at para 25, Lordship. Is passed by the Guwahati High Court, Lordship.
Yes.
May I read, Lordship? This court, in the case of such and such, reported in 2013 3 GLT 589, had an occasion to deal with the provisions of Order 18, Rule 18, and observe the very purpose of this particular provision is to help the court to understand the evidence brought on record by the witness of the parties before the court, and up to the limited extent the court can conduct inspection of any property or thing connected with the property. Paragraph 16, 17, and 18 being relevant are quoted herein below. 16, in order to appreciate the arguments advanced by the learned counsel for the parties to know which side of the story is true, I find it necessary to appreciate the provisions of law in the light of decision referred to by the parties before this court. For ready reference, the provisions of Order 18, Rule 18 of the CPC is reproduced. As if this may not be necessary to read it again. Paragraph 17, ongoing through the aforesaid provision of law, I have found that the very purpose of the Order 18, Rule 18 of the CPC is to help the court to understand well the evidence brought on record by the witnesses of the parties before the court, and up to that limited extent, the court can conduct spot verification of any property or thing connected with the suit. Therefore, at any stage of the suit, in my considered opinion, means any time after putting in evidence on record by the parties of any one of them. Here, it needs to be remembered that if a judge is allowed to conduct inspection of such property thing even before recording the evidence, then there is a very possibility of such a judge becoming witness to any of the parties to the proceedings before him. But such on eventuality has strongly been deprecated by the provisions of law which makes such inspection possible. In that view of the matter, a judge cannot be allowed to make inspection of the suit land even before recording of the evidence. Because if a judge cannot be allowed to make inspection of the suit before recording of the evidence, the learned trial judge had formulated two issues, Lordship. In that issues, evidence was not recorded. So this spot verification.
So at the time of the appeal, did you raise these points before the court? You raised them, isn't it? So if you are unhappy with the judge, anyways, we'll listen to the opposite party first.
Yes, Lordship, no problem.
respondent. Yes,
Your Lordship.
because I should not be doing your homework.
Um,
Yes.
Yes, my
You have
lord.
filed your objection?
Yes,
Oh.
I filed,
Yes.
already filed the objection. Yes, my lord, the grounds stated by the review petitioner, my lord, it cannot be considered as a valid ground as per Order 47, Rule 1.
What does Order 47, Rule 1 say?
My lord. Order 47, Rule 1. If I may read it, my lord.
Yes.
Application for review of judgment. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by B, by a decree or order from which no appeal is allowed, or C, by a decision on a reference from a court of small causes, and who, from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the report, or for any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the court which passed the decree or made the order. So, my lord, as already stated in my application, the grounds as submitted as stated by the review petitioner cannot be a ground for review under Order 47 Rule 1, as there are no new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the review petitioner and nor could be produced by the petitioner at the time when the decree was passed and order was made in the connected RFA number 20 of 2018. And my lord, as already stated,
What
by
is the
my-
point for his review? What point did he raise for review?
my lord, page number 5 of the review.
You should be
the
knowing
grounds.
you filed your objection. What
Yes,
point was raised?
my lord,
Yes.
I'm coming to that.
Yes.
Yes, my lord, I'm coming to that. As stated by my learned friend, regarding the failure of the learned trial court in complying with Order 18, Rule 18, it can be clearly seen from the judgment order dated 27/5/2022, passed in the connected RFA number 20 of 2018, that, my lord, the same has already been raised. The same has already been raised in the connected appeal. The
Where?
grounds that
Page, para what of
yes,
the
my lord,
judgment?
A Roman number, the 9, no, my lord, 10, paragraph number 17, 18, and 19 of the judgment order dated 27/5/2022. May I read? Yes, ma'am. It is seen that due to the conflicting reports made by the state respondents regarding the disputed area lying between the LSCs of the appellant and the respondent number 1, a local commissioner was appointed by the learned trial court by order dated 13/1/2016 to conduct spot verification to ascertain as to whether the LSC number 68 of 1971 and LSC number 829 of 86 encroached each other, and whether there is a vacant government land measuring 0.40 meter between the said LSC number 68 of 1971 and LSC number 829 of 86. However, no report was submitted, and the trial court then conducted the spot verification herself. At para 20 of the judgment, the learned trial court has noted that, as suggested by the counsels and in the interest of the case, the court found it necessary to conduct spot verification. Thus, at the very outset, it is seen that the counsel for both the parties had suggested that the spot verification be conducted, and the counsels for both the parties were present when the spot verification was being conducted. There is no mention of any objection being raised by neither of the parties while the spot verification was being conducted. So, my lord, no objection was being raised by both the parties at the time when the spot verification was conducted, and
Yes,
it
okay.
appears that
So it
both
was
the par-
already discussed, no
yes,
new
it
grounds.
was already
Yes.
discussed out here in paragraph 17, 18, and 18 is the observation made by the learned trial court, and in paragraph 19, it the honorable court
Yes, upheld that
upheld
observation.
that this
Okay.
court finds that since the spot verification was done on the suggestion and in the presence of the counsel for both the parties, the findings and observations made therein, which is in the interest of the case to secure the ends of justice, could not be questioned at a belated stage. So, my lord, the decision arrived by this honorable court can hardly be considered as an error apparent on the face of the record. And the fact that the land measuring 0.40 meters between the said LSCs has already been mentioned in the said paragraphs already. And the same has been considered, was duly considered by this honorable court, and the same cannot be grounds for review, my lord. So in other words, my lord, the said grounds does not highlight any discovery of new and important matter or evidence, which Order 47, Rule 1 has stated as applicable grounds for review. And the decision rendered by this honorable court cannot be considered as an error apparent on the face of the record. And as such, my lord, this application is devoid of any merit and
Yes,
is accordingly fit to be dismissed. That is my submission.
you are, anything for the government, anything to mention? You're also a party?
As per instructions, the respondent does not have anything to add besides what was already submitted as pairwise comment in the civil suit.
Yes. Heard both the parties. I'll pass the order later. Review petition is dismissed.
Lordship, so we are the legal aid counsel, Lordship. in
Yes,
this
my lord,
regard.
even I am the legal aid counsel for
Okay.
the respondent one.
Okay, legal aid counsel?
Yes,
Yes.
my lord.
Try and settle the matter.
Yes,
They are
all of it.
neighbors,
Yeah.
all little land
I understand, Lordship.
steps.
Yes, yes.
Yes, okay, fine.
Item 4.
Now, wait, if you are the legal aid counsel, you'll be getting your fees from the Office of State Legal Services Authority or
Yes,
district?
Lordship.
So do we have to mention that or not required?
I think it may be necessary to mention, Lordship.
Okay, that your fees be paid as per the what? Standing, there must be some order concerning.
Some orders,
okay?
also,
Okay,
yes.
fine, I'll pass those two.
Lordship.
Yes.
4.
I please your lordship. In compliance with the order dated 4/7/2024 and 12/8/2024, my lord, the respondent number 4 was directed to file an affidavit, which will be filing during the course of the day, my lord. It's all prepared.
You're for respondent number 4.
As per the order, the respondent number 4 was directed to file affidavit, my lord.
Well, you have to file something, isn't it? Wait, let's see. Okay, the respondent number 4 shall look into the claim made by the petitioner that his scooter bearing so-and-so has been seized by respondent's number 7. Respondent number 4 is whom?
The SP, Aizon.
Okay, you're representing SPI.
Yes, my lord.
So has it been seized or not?
It has already been given back to the petitioner, my lord.
Okay.
That we have stated in the affidavit, which we will be filing today, my lord.
So if that has been given back, now what's your grievance
My lord,
in this case?
the facts of the case is that
You were asked to vacate the place, isn't it?
Yes,
Some
my lord.
village?
by the JSC, the Joint Action
So
Committee.
most probably who is important here is the JAC.
Yes, ma'am.
Anyone representing? Yes.
Yes, my lord. Respondent number 6 to 8.
Huh.
I
You will have to file your counter, isn't it?
Yes, yes, my lord. Along with my power.
Okay. Heard Mr. Rala Rokunga Pautu, learned counsel for the petitioner, along with Mr. Samuel L. Sangte, learned government advocate for respondent government advocate, who submits that he will be filing his affidavit in terms of this court's order dated 12/08/2024 within the course of the day. The learned, instead of government advocate, additional AG, okay? The learned addition AG submits that in terms of this court's order dated 12/08/2024, he was supposed to file the affidavit and look into the claim made by the petitioner with regards to his scooter bearing registration number MZ056146 being seized by respondents number 7 and 8. Full stop. The learned Additional AG submits that the said scooty bearing registration number so and so, okay, has been released and returned to the petitioner
If a date is necessary, Your Lordship, on 12/8/2024.
on 12/8/2024, and he will be filing his affidavit to that effect within the course of the day. Full stop. Mr.
Yes, Valalsheta.
S. Vanalshiata appears. Have you filed your par?
My lord.
You have filed? Appears
filed,
on
yes.
behalf of respondents number 7 and 8 and 7 and 8 and has prayed for time for filing of their counter affidavit. In view of the above, list after 2 weeks?
2 weeks.
Simple matter. Find out
Yes.
what's going on. Yes.
Obliged.
Item 5.
Yes. Oh, what is the stage? Counter affidavit.
Your Lordship, we have sent a reminder on behalf of Government Advocate Bimali, and we are yet to receive instructions from
Okay.
the respondent.
Miss so and so, learned government advocate, has prayed for further time to file their counter affidavit. What is the stage? What steps are being taken by the
stage.
government?
Your Lordship, I am not familiar with this case.
Find out. Okay,
Yes, Your
call the concerned department. Yes, has prayed for further time to file their counter affidavit. In view of the above, list after 3 weeks.
Yes, Your Lordship.
Item 6.
My lord, there's a development in this case. They have compromised the dispute. If I may take your lordship to the memo of appeal, the impugned heirship order in the certificate. This heirship certificate, the certificate on the third page, after the order, after the impugned order. It's just next to the index in the RFA.
In the RFA,
Yes, my lord. Next to the index, there is an order of the
okay,
heirship.
anyway, what are you trying to show me?
The disputed properties, my lord.
Okay. Yes,
Have you
heirship
got the
certificate,
certificate?
yes. Two this thing, serial
Yes, my
number,
lord.
land lease,
Land
yes.
lease certificate, and number 2 is retail outlet dealership petrol pump. And here, my lord, Lalmuan Kimi, the deceased, Malsom Zwala is the nephew of Lalmuan Kimi, to whom this impugned heirship certificate was granted. And the present appellant is the surviving husband of Lalmuan Kimi.
Okay, for how many years were you married?
They were married on 2014.
Okay, and when did she die?
He expired on December 2022.
Okay,
And what
almost
happened here
10
is
years.
that, my lord, earlier this Malsom Zola had applied for heirship certificate without the knowledge and consent of the appellant husband. And I have raised an objection. As a result of that, we have made an agreement. And as per the agreement, he had withdrawn the earlier heirship certificate. And in terms of the agreement was that we will consider to whom it will be granted. But again, without my knowledge, he had applied for this impugned heirship certificate. But now there's a problem with this because after this person, Malsom Zola, was granted heirship certificate in respect of this petrol pump. But the IOCL, Indian Oil Corporation Limited, they cannot process anything without declaring the surviving husband as the legal heir. So now they have made an agreement between the rival parties.
Okay, where's the, okay, fresh agreement, is
Yes,
it?
madam.
Yes, let's see, copy. Is the respondent represented, you're representing? Okay, good.
Yes, Lordship.
You know about the agreement?
Yes, Lordship. Lordship, as instructed by the respondent, we have no objection in the
Okay.
instant appeal for granting the petitioner to be the legal heir of his wife.
Okay, so you have come before this court for withdrawal? Or
No,
what?
my lord. I have to be declared as the legal heir. That has to be done by the trial court. So this impugned heirship has to be set aside for this purpose.
Okay, anyway, let's see the agreement.
Yes, my lord. I have the
Yes,
translated copy.
yes,
Point number one.
translated, yes.
Point number one. Reconstitution will be undertaken in the name of David L. Ramsiyama. He is the present appellant. Reconstitution means the registration of the petrol pump is in the name of the deceased person, and it has to be reconstituted in the name of David L. Ramsiyama. And for this purpose, I have to be declared as the legal heir. And number two, the profit will be divided into 4 shares. Here, my lord, if you look at the signatories down there, Lalton is the father of Lal Monkimi, Roding Liani is the mother of Lal Monkimi, third one is the present appellant husband, and Mal Songzor, the nephew. Their family will get 3 shares, I will be getting 1 share. This is the family agreement. And for this purpose, the impugned heirship certificate has to be set aside, and I have to be declared as the legal
But
heir.
what about the land lease? This is concerning the filling
my lord.
station,
Yes,
but
my lord.
there's this LSC also.
They are all connected because when the petrol pump was applied, the land property itself has to be the name of the same person.
Okay. So this land lease certificate and the petrol pump, it's one and the same property.
Yes, my lord.
So no objection?
No objection, Your Worship.
Okay, heard Mr. Victor L. Rante, learned counsel for the appellant, along with Miss
Harin Thari.
Lalrin Thari, learned counsel for the sole respondent. The learned counsel for the appellant submits that the parties have come to an amicable settlement on 17/05/2024. Wherein it was agreed that the reconstitution of the Dingdi filling station, Kanmun, Mamit district will be undertaken in the name of the appellant, and that the profit will be divided into 4 shares. The parties to the agreement into 4 shares, wherein the father, Mr. Lal Tona, father of the deceased Lal Monkimi, Roding Liani, mother of the deceased Lal Monkimi, and Lalmal Somzwala.
Mal Somzwala.
Lalmal Somzwala.
Mal Somzwala.
Yes. Nephew of the deceased Lal Monkimi, within brackets, respondent number 1, will be getting 1 share each, and the appellant, David Lal Ramsiyama, will be getting 1 share. That since, full stop, the learned counsel further submits that since the parties have come to the amicable settlement, they prayed that the impugned heirship certificate issued by the Court of Civil Judge, within brackets, Senior Division, Mamit District, Mamit, may be set aside, and the heirship certificate may be issued in his favor for necessary steps to be taken by the appellant in terms of the agreement arrived by the parties on 17/05/2024. Ms. So-and-so, learned counsel for the respondent, submits that they have no objection to the prayer/submissions made by the learned counsel for the appellant, since the parties have come to an amicable settlement dated 17/05/2024. In view of the above submissions, this court find it fit to set aside the heirship certificate,
Number,
heirship certificate application number 46 of 2023, issued under section 30 within brackets 3 of the Mizo Marriage, Divorce and Inheritance of Property Act, 2014, dated, what's the date? 3rd November 2023, in memo number 464/HC/CJ within brackets senior division close bracket within brackets M/2023, dated Marmit 3rd November 2023. Okay. And direct that heirship certificate should be issued in the name of so-and-so.
David
The appellant David so-and-so, by the learned judge, civil judge, senior division, so-and-so, okay, Marmit district, accordingly RFA number 48 of 2020 stands allowed and disposed of.
this agreement may be
Yes,
made a part of the record.
the agreement dated so-and-so is to be made a part of the record and marked as X. Yes.
Item 7.
There is an IA which can be disposed of in the same line.
What is the IA about?
To stay the impugned heirship.
On the disposal of the instant RFA 48 of 2023, the IA number 153/2023 stands disposed of.
Thank you, Vice.
Item 7.
Yes.
My lord, I'm for the respondent number 4. I may be given another 3 weeks time for filing my affidavit.
Yes.
My lord, I'm also appearing for respondent number 3. If I may also be given some time to, because I need to get some more documents.
You are for respondent number?
3, Kala, Saitwal district.
See, this court in its last order had observed that several opportunities were granted to the respondents to file your counter affidavit.
My lord, we in the last court date we had submitted the wakalatnama. We've just filed our power.
Yes. I heard Ms. Zaram Sangpui, learned CGC.
My lord, small prayer, small submission. If this has elongated quite long, so if it may be given like two weeks time,
Okay.
3 is quite
Anyway, I
long.
heard Ms. Valentina so-and-so, learned counsel for the petitioner, along with Ms. Zaram Sangpui, learned CGC, for respondents number, respondent number? 4. And Ms. So-and-so, learned counsel for respondent number
3.
3. The learned counsels for the respondents have prayed for further time to file their counter affidavit. Mr. Samuel Vanulsheta Sangte, learned standing counsel for respondents number 5 and 6, submits that they have already filed their counter affidavit. In view of the above, This is matter after, yes, 3 weeks. We'll give them 3 weeks.
Obliged. Obliged.
Item 8.
Now, this is a jail appeal, is it? And this is a jail appeal filed against the judgment and order dated 18/04/2024 in criminal appeal. Okay, wait. Okay, against the judgment and order dated 18/11/20. No, this is the second appeal against. You see, now the appellant had first appealed against the order of the magistrate first class before the district and session judge. Then I think the district and session judge upheld the order. And therefore they have come to this court as a second appeal. This is an appeal, a second appeal filed against the judgment and order passed. It will be under which section of law?
But, if there can be second appeal in criminal.
That's what I'm wondering. Under what section of law can we consider this? You have it in the CPC, but in the CRPC and appeal, anyone to highlight the court?
But they can come in revision, I think. Under 482.
I don't think this is possible. Now here, the appeal is made, you see, against the judgment. Now here, the judgment is dated 3rd February 2022, and he was sentenced for 1 year. So I wonder if he's still in jail also. And he has made the application against the judgment and order of the magistrate first class. But here I find an order of the district and session judge is also enclosed. And the judgment is dated 28/11/2023, 1 year. Okay, so 2024, there's still a few months. So anyways. This is an appeal against the judgment and order of the Judicial Magistrate First Class, dated 28/11/2023, wherein the appellant was sentenced to undergo RI for a period of 1 year and pay a fine of rupees 1,000 in default for another SI for another period of 10 days. On his conviction under section 6 within brackets 1 and 14 of MLP Act in criminal trial number 136/2022, vide MENS case number 28/2022. Full stop. A perusal of the documents enclosed. On perusal of the documents enclosed, this court finds that the impugned sage judgment and order dated 1804. Impugned judgment and order dated 28/11/2023 had already been appealed against, and the sessions judge, Isol in criminal appeal number 2/2024 vide its order dated 18/04/2024 had disposed of the appeal by upholding the judgment and order dated 28/11/2023 and the sentence order dated 25/1/2024. By disposing of the appeal. In view of the above, find out whether they can come before this court, because we'll have to look at the CRPC again a little bit. Okay.
A copy may be furnished to me so that we can examine it.
Can we just have a look and find out? Anyone to assist this court in this matter? When we say whether a second appeal is allowed or not, there's this niggling doubt in my mind, because then they approach the apex court, isn't it, in such matters?
My lord,
Yes.
subject to the manner of the grievances against the impugned order, they can approach the higher court under 397 and
Yes, let's
482.
see, yes. You see, but the mistake which the appellant has made is that he is still filing the appeal against the judgment and order of the magistrate first class, when it should be from the district judge. Anyways, the appeal should be against the judgment and order of the district judge, sessions judge.
But my
Isn't
lord,
it?
in my humble opinion, if the session judge upheld the magistrate order, both the order has to be challenged by way of revision under 397
Okay.
or 482.
So in the appeal, he has come only, anyways, we'll issue notice. Let's see. Okay. Yes. Has already disposed of the so-and-so by the order dated so-and-so. Just read the last sentence. Read the last sentence. The appellant being dissatisfied with the judgment and order of the magistrate first class, dated 28/11/2023 and the sentence order dated 25/01/2024 and the judgment and order of the sessions judge in criminal appeal number 2/2024 dated 18/04/2024 has now approached this court. Issue notice to the state respondents, Ms. Linda L. Fumba. Learned PP accepts notice on behalf of the state respondents. Requisite extra copies of the appeal to be duly furnished to the learned PP. LCR is to be called for. List after 2 weeks.
Item 9.
My lord, during dependency of this case, the respondent sent letter to the petitioner
Yes.
by requesting to submit the relevant document to the department for processing their pension, my lord. If I may permitted to produce my instruction letter.
What are your instructions? Not to file counter?
No, my lord, they requested the petitioner to submit some relevant document for processing their family pension, my lord.
Who is the counsel for the petitioner?
No, my lord, the counsel for the petitioner is on the way. In stack of exam. Then he requests me to fix the matter in the incoming Thursday, my lord.
Now, this is regarding grant of family pension.
Yes, my lord.
Is it? And you're saying that certain documents were called for.
Yes, my lord. I thought that the petitioner also already submitted to the respondent, my lord.
The documents that are required.
Yes, my lord. After receiving this letter, my lord.
So then your next step is to release the pension, isn't it?
It's, my lord, the petitioner may submit that, we asked to whether he submitted, he replied this letter or not, my lord. Then the matter may be taken up again on Thursday.
Heard Ms. Mizaram Sangpai, learned CGC, appearing for the respondents. Full stop. The learned CGC submits that the respondents, while their letter dated 18 July 2024, had requested the petitioner to furnish certain documents. Full stop. She further submits that if the said required documents are submitted, the respondents will be able to file, take necessary steps and file their counter affidavit if required.
Yes, Madam.
It is seen that the learned counsel for the petitioner is not present. In view of the above, list this matter on,
Thursday.
yes, what's Thursday date? 29, so and so, yes.
Oblige.
For order, item 10.
Yes,
My lord, on behalf of the applicant's counsel, my lord, I have been requested to make a mention this. Since this was not given particular date in the previous date, this came up for today, but they were not aware of this. And they have no time, since they're from out of station, they have requested me to. This is the case again on 3rd of September.
they were absent in the last date,
Yes,
it
my lord.
appears.
When particular date is not fixed, my lord, they're having problem. So they will,
They should check the cost list every time and see when it's listed, isn't it? Who's the counsel?
Dinesh Kumar Sharma and B. Pathak.
Yes, so you're making a mention on their
their
behalf. Mr. Victor L. Ralte, learned counsel, makes mention on behalf of the learned counsels for the appellant, submitting that since a date was not fixed for listing of the matters, of this matter, the learned counsel for the appellant, being an outstation counsel, has failed to appear before this court today. Ms.
Vane Isyami.
Vane Isyami, learned government advocate for the state respondents, is present. See, I've just noticed that in this court's order dated 14/06/2024, also same prayer, outstation counsel not mentioned. Anyway, in view of the above, list after,
List on 3rd September, my lord,
that will be 2 weeks or 3 weeks?
next week.
Okay, list the matter in the next week on 3rd September. Yes.
Deeply obliged.
For hearing, part 2, item 1.
Yes, are we ready? This is a 2014 case,
Yes, that's it.
very voluminous also.
In order to cut short, Your Lordship, the matter,
Facts of the case itself. Ah,
to cut short the matter, Your Lordship, may I take Your Lordship to page 108. This is the order which was impugned during the trial court. There's an order dated 7 May 2010. I'll just go through, Your Lordship. Order from miscellaneous pass number 4 of 1971, owned by Mr. Mandos Rai of Zotlang, LSC number 647/74, with an area of 17.5 bigas, and LSC number 67, 1975, with an area of 15.24 bigas, were made, both in the name of Mr. R.C. Rokuma. One of the LSCs, LSC number 647/74, was again segregated into 2 LSCs, such as LSC number 705/76, with an area of 11.87 bigas in the name of Mr. Rokuma, and LSC number 747/74, with an area of 5.62 bigas in the name of Mrs. Ralman Tangi. LSC number 705/76, with an area of 11.87 bigas was again segregated into various portions as mentioned below. There are as many as 11 allottees.
Okay, so,
The total area.
wait, so it is the LSC of Mr. R.C. Kumar,
RC
which
Kumar,
has
R.C.
been
Kumar.
again
Yes.
segregated into,
Yes.
okay,
Yes. So the total area of those 11 LSCs has come to 7.43 bigas. And the original area of LSC 705 of 76 is 11.87 bigas. And the remaining portion appears to be 4.44 bigas. And if I take lordship to the next page at page 1110,
so what is the last part here?
Last
Apart
part,
from
yes.
this, so this 4.44
yes, 4.44.
was again segregated into 3 LSCs, is it?
No, no.
Then
no,
what is
lordship.
this?
I'll take a lordship to the last part, page 110.
Okay.
In response to the show cause notice, I'll just take a lordship to this paragraph. In response to the show cause notice and in favor of LSC owner, Mr. Zhou Mangaya, IRS, retired, submitted letter dated 15/4/2010, after careful consideration was made based on the response that he submitted, it was decided that there was no valid reason found for not cancelling the LSCs. Therefore, the 3 LSCs and all other LSCs sliced out from LSC number 53881 are cancelled via government letter number so and so. So these 10 LSCs have been cancelled. However, Lordship, there's a statement here in this second last paragraph. For all the cancelled LSCs, the owners will be losing them after thinking that they have owned it for a long time, and it is therefore decided that the alternate LSC should be arranged for them. On segregation of LSC number 705 of 76, it is identified that a vacant land of 4.44 bigas would still be available even after measuring out the existing LSCs. After spot verification of the vacant land, the vacant area would be used for altering Mrs. Vandalringi's LSC's number 538/81 and all the above mentioned LSCs sliced out from it. Mrs. Romoy's LSC number 13782 and Mrs. Ralmantangi's LSC 5389 of 81 are also shifted inside the vacant area of Mr. R.C. Kumar's Pipata number 934/76 located at Rangunwa. Lordship, in this connection,
Wait,
Right
let's understand this letter also.
Yes.
See, here you have about 9 LSCs mentioned,
yes,
which is out of the LSC 705, isn't it?
705, yes.
Yes. Then,
Out of this
then out
705,
of page 110, you led me to the cancellation of the LSCs again. These cancellation of the LSCs are completely different LSCs because
Therefore, the
names
three-
are different.
yes, these are this Romoi, Ralmantangi, and Vandalringi, the LSC in the name of Van
Yes. So,
538 of 81. So out of this 538 of 1981, all these subsequent LSCs have been sliced out.
which
However,
ones? Which
all-
ones? 538.
This 4, 5, 6, 7, 8, 9.
Therefore,
and
the
10.
3 LSCs are sliced out from cancelled. Now, why are these cancelled? Because,
Therefore, the 3 LSCs and all other LSCs, the 3 LSCs are, let's say, mentioned here. Zhonghuang's
okay,
LSC,
the remaining
538.
part out here.
Yes.
Okay,
538, 539, and 137 of
okay,
82.
these 3.
These are the
okay.
3
Yes,
LSCs.
page 109.
Yes,
Page 109, certain LSCs were mentioned,
Yes.
and that has been now cancelled.
therefore, the 3 LSCs and all other LSCs sliced out from 538 of 1981 are cancelled. White government letter number so and so. The cancelled letters are as follows. And here, it is stated at the end of the order, the second last para, for all the cancelled LSCs, the owners will be losing them after thinking that they have owned it for a long time, and it is therefore decided that alternate LSC should be arranged for them. On segregation of LSC number 705 of 76, it is identified that the vacant land of 4.44 bigas would still be available, even after measuring out the existing LSCs. After spot verification of the vacant land, the vacant area would be used for altering Mrs. Van Ring's LSC number 538 of 1981, and all the above-mentioned LSCs slice out from it. Mrs. Romoy's LSC 13782 and Ralman Thangi's LSC 539 of 81 are also shifted inside the vacant area of Mr. R.C. Rokuma's Pipata number 934 of 1976. Lordship, at this stage, may I take back Lordship to the order dated 18/2/2021. 18/2/2021.
Page,
In the record. Your
okay.
Lordship.
Order of this court.
Orders of this honorable court. A submission was already made on behalf of the appellants by Mr. Jonathan L. Silo. Has the Lordship got it? 18/2/2021.
Let me come to the order. Yes.
So here, a submission was already made by Mr. Jonathan L. Silo.
Okay, willing to come to a compromise.
Yes. And he said that the second last para which I have read out is there. And in view of this, Jonathan L. Silo, Learned Counsel, submits that if the state respondents are willing to compromise the matter, they will drop their claims made against the private respondents. They means the appellants. They will drop their claims made against the private respondents. So, if the state respondents, since they have already stated that 4.44 bigas is still remaining out of that 705 of 76. So, in that vacant land of 4.44, all these cancelled LSCs can be put in. And if there are certain LSCs which cannot be fit into this 4.44, that there are still other portions belonging to Mr. R.C. Rokuma, which is LSC Pipata number 934 of 76, located at Rangomwal. So there's a possibility of coming to an amicable settlement.
Amicable settlement. Okay.
And the matter may be referred to Lok Adalat
Yes.
for settlement. And of course, the state will be a very important party because they have taken all such measurements. They have marked out all those LSCs, and they have stated that 4.44 bigas is still remaining vacant. And though we may not be able to remain in the same location, but if we are within the said 705 of 1976, in the
Somehow
vacant land.
maybe you can come to some
Yes.
settlement, is it?
Yes, that kind
Now,
of settlement,
okay.
if that can be reached, I think it will be good for the parties.
Yes, what is the response of the respondents? 2911,
Yes,
okay.
my lord. The next order. There, my lord, we have, we could not come to any compromise. Yes, the parties could not come to a compromise.
Seen that the last order by this court dated 18/2/21. that
Oh,
Learned
yes,
Counsel
this is
for
my
the applicant
order.
has submitted that the state
19.
respondents, having had the learned counsel for the parties, it appears that the private appellants
Okay,
and respondents are not
so
adverse
list
to
after
make.
1 week.
Your Lordship, what is
So
given
nothing
here?
is mentioned whether they want to,
No, having
having
passed
heard the submissions of the learned, it appears that the private appellant are not adverse to
are not
making an
adverse to make an
attempt.
attempt to
You are
settle
not
the matter
against,
outside court.
okay?
Yes.
You are not adverse to making an attempt, and that you will consult and come back after 1 week. Now, after 1 week, what happens is, learned counsel, Mr. Jonathan is absent. Nothing is mentioned. Then again, nothing. So now there's no mention again whether you want to have the matter settled outside court or not.
I think there's no problem, Mr. Zongpangaya.
You were not adverse
Having
to the
died.
idea. Okay, yes. So now what about the private respondents? What do you have to say in this matter?
Your Lordship, so far as my land passage is not affected.
They're not
If
affected.
It can, if
It
it
can be
can
settled.
settle, I have no
Okay.
problem.
So now the last order was that you were not adverse to the idea. That means you didn't say no. So Ms. Linda, which department are you going to consult?
Revenue Department.
Revenue? Any other department involved? Only revenue?
Only revenue, Your Lordship.
Then find out from the revenue department.
Your Lordship, if the matter is placed before the Lok Adalat and the revenue department is represented by the competent officer, then the parties, the appellants and the respondents, private respondents,
Yes,
they are in the mood
we
to
can refer the
compromise.
matter first. Let at least one attempt be made. No previous attempts were made?
No,
Yes.
Yeah, you have.
attempt,
Yes,
proper
Yes,
attempt was
okay.
And Your Lordship, what I'm thinking is that first, it's a long time back the order was passed, and I first it has to
Okay, consult your clients first.
ver-
Okay, get some
verification.
instructions. Okay. We're waiting for. Where's this landed property, disputed property at
It's,
Rangomod?
in
Is it?
Zotlang.
Zotlang.
Yes.
Okay, somewhere I read Rangomod out here, no?
Rangomol is another
Another-
pipata belonging to Mr. R.C. Rokum.
Okay, that's not disputed?
It's not disputed. If there are, the land is in excess of 4.44 bigas, then still there's a possibility of shifting the other LSC owners to that place also, as part of this order.
Rangomod.
Yes. At Rangomod.
Because Zotlang is,
Matter could have been settled long time back, in fact.
Because, yes, because here, this court's previous order was that you were willing to make an attempt, and then the next order was that the state respondents also not adverse to the idea and to come back to the court after 1 week. But once the matter was listed again,
Yes.
you failed to mention that whether you were willing to make an attempt or not. So the matter has been kept pending for, yes, over a year to decide whether you want to have the matter referred to Lok Adalat or not. So we'll fix a short date. Okay, where you parties will come back to this court and inform whether you are willing to have the matter referred to Lok Adalat or not. Isn't it? So, yes.
So Lordship, if the matter is referred even now, if there can be conciliation, if they come to amicable settlement, it's well and good. But
Yes.
earlier also, we
So
have,
without consulting your clients, if
Yes.
you feel that there is a chance for an amicable settlement, okay.
there's a possibility.
Yes, what's wrong? They're not there in their room. Okay, where's this thing, Zote? What's happening? Heard Mr. C. Laramzawa. Learned counsel for the appellant, along with Ms. Denari, also learned counsel for respondents, private respondents
Private
number.
respondents number,
Okay, private respondents. Yes.
All private respondents.
We'll just make it private respondents. Learned counsel for the private respondents, and Mrs. Linda L. Pombal, learned additional AG for the state respondents. We'll stop. The learned counsel for the appellant submits that as per the order dated 07/05/2010, passed by the Director, Land Revenue and Settlement Department. It is clearly mentioned that there is an area of 4.44 bigas remaining from the LSC number 705/76 belonging to Mr.
R.C. Roku.
Okay, R.C. Rokuma, after it being segregated into various portions. The learned counsel submits that in view of the area of 4.44 bigas remaining from the said LSC, there could be a possibility of the parties coming to an amicable settlement if the state respondents do not what? What is your suggestion? Do not?
If the state respondents comply with the amicable settlement proposed,
No, if this, no, of the parties coming to amicable settlement,
in fact, it is they who had made the verification, who had marked out the lands, and who had said that there is a vacant land of 4.44
okay,
because
let's leave
within
it at that,
705.
amicable settlement, full stop. Okay. The learned counsel for the private respondents have not objected. Okay, should we refer it straight away, or you want to get instructions first? You
for
will
me-
refer
for
it
me-
straight
for
away.
me,
We'll refer it straight away, and then we can see. Okay. Settlement.
And Your
It is
Lordship,
noted.
during the compromise, it's required to verification because the
All
order
that,
passed
all
in
that you can do
2010.
it at the through local
Yes,
adalat,
yes.
okay? It is noted that this court, by its order dated 29/11/2021, had observed that the respondents are not adverse to make an attempt to settle the matter outside court. Full stop. In view of the above, this court find it fit to refer this matter to the Lok Adalat organized by the Legal Services Committee, High Court Legal Services Committee, registry to do the needful. Yes.
Applies.
I think we'll leave it at that, isn't it? Yes.